And welcome back. Time for this week's Capitol Report with Pat McGuigan of CapitolBeatOK.com. Pat, at least in the legal policy arena, the big news of the week is the federal district court decision in which State Attorney General Scott Pruitt took the lead, so to speak. And you've analyzed this decision. Tell us about that and what comes next.
Yeah, it's interesting. It's not the first decision of this nature, but it was the first filed back in 2012 by Scott Pruitt. And in essence, he triggered a national argument and won the case. Judge Ronald White in the Eastern District of Oklahoma said there's two aspects that make the IRS rule issued under the authority of the Affordable Care Act make it problematic. The first is that it's federal compulsion, the federal government forcing the states to do something, which he argues is beyond their power to force a state to accept a program it doesn't want to accept. But then he goes on to add that the explicit language of the act was part of the debate and argument in Congress. The explicit language allows the states to withdraw, and the Supreme Court affirmed that a state does not have to does not have to set up an exchange. So, no matter how you look at it, Judge White said, the IRS ruling compelling the states to have these exchanges and to provide subsidies and so forth, all the things involved with Obamacare, as people call it, the ACA, falls. It falls by the wayside either under statutory construction or constitutional provisions. And by the way, an absolute majority, 36 of the 50 states, have declined to set up these exchanges. The Obama administration said that that provision in question was actually intended to assume by inference that there would be an exchange in every state. But White wrote that that was a Alice in Wonderland form of judicial construction, saying that up is down and down is up, and that words can mean anything you want them to mean. And Judge White at least said that's not the case. As a result, this is invariably going to wind up before the U.S. Supreme Court because there's two different interpretations of all these provisions in different circuit courts. This one will go up to the 10th Court in Denver, and then I wouldn't be surprised if the Supreme Court's grappling with the conflicts of those three.
Very interesting. We'll continue to watch it. Now, you attended the first ever national meeting of the Free Market Medical Association. It was held right here in Oklahoma City. Any big news out of that conference?
Yeah, this is the program that they had, and this was basically came out of the work of Dr. Keith Smith and Dr. Steve Lantier, who we've talked about before, the guys that founded the Surgery Center of Oklahoma here in Oklahoma City, which has been pioneering the use of market forces to drive healthcare costs rather than government mandates. They covered thinkers, doers, users of healthcare services, forecasts, ideas, how to create a free market in your town. They talked about issues like direct pay, just simply paying cash for your healthcare, leadership, free market principles, price transparency, which is one of the things they're known for, and finally, self-financing, which is the big trend in the healthcare industry, I should say the businesses, in terms of providing insurance to their employees. So it was a big conference.
All right, you can read more about these and other topics at CapitolBeatOK.com. For Pat McGuigan, I'm Alex Cameron. Have a great day.